be sufficient given what we've heard. And 20, Ms. Pritikin would include if you wanted to reserve any part of that 20 for rebuttal.
Yeah, I'd like to reserve about 5 minutes.
You want me to keep
I probably
track of that
won't
for you?
use the full 15, so
Want me to keep track of that for you, or
if you could,
I will. I'll tell you when you get 5 minutes.
but probably
left.
15 and 5 is fine.
Give you a 5 minute. If there's 5 left, I'll give you a heads up if you're not done already.
Thank you.
Mr. White, would you like me to do anything for your timekeeping, or you'll do it yourself?
How much time was the court?
20?
Maybe just get a 5-minute one. You know?
Okay, we'll do that for you. All right, well, let's bring the jurors in. Do those now, and then we'll hear closing arguments. We'll hear first from Ms. Pritikin, then we'll hear from Mr. White, and then if Ms. Pritikin reserves time, she can be heard last because she does have the burden of representing the state. So it's appropriate, but you'll have a copy of this to go with you into the jury room. So this is my instructions to you, my jury. Off on these in the state of Washington versus Matthew Arith case. And instruction 1, and don't panic, they're not all this long. So people, some are very short. So instruction 1, it's your duty to decide the facts in this case based upon the evidence presented to you during this trial. It's also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the facts that you decide have been proved, and in this way decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. And the evidence that you are to consider during your deliberations consists of the testimony that you have heard from witnesses and the exhibits that I've admitted during the trial. And if evidence was not admitted or stricken from the record, then you not consider it in reaching your verdict. Now, exhibits may have been marked by the court clerk and given a number, but they do not go with you to the jury room during your deliberations unless they have been admitted into evidence. The exhibits that have been admitted will be available to you in the jury room. So one of my duties has been to rule on the admissibility of evidence. Don't be concerned during your deliberations about the reasons for my rulings on the evidence. If I have ruled that any evidence is inadmissible, or if I've asked you to disregard any evidence, then you must not discuss that evidence during your deliberations, nor consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. And each party is entitled to the benefit of all of the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness, and you are also the sole judges of the value or the weight to be given to the testimony of each witness. And in assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. And in considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or to know the things he or she testifies about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all of the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. Now, the lawyer's remarks, statements, and arguments are intended to help you understand the evidence and to apply the law. It's important, however, for you to remember that the lawyer's statements are not evidence. The evidence, again, is the testimony and the exhibits. The laws contained in these instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence or the law in my instructions. You may have heard objections made by the lawyer during trial, and each party has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you. Do not make any assumptions nor draw any conclusions based on a lawyer's objections. Again, our state constitution prohibits a trial judge, and that's me, from making a comment on the evidence. It would be improper for me to express by words or conduct my personal opinion about the value of testimony or other evidence. I have not intentionally done this. If it appeared to you, though, that I have indicated my personal opinion in any way, either during trial or in giving these instructions, you must disregard this entirely. You have nothing whatever to do with any punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They're all important. And in closing arguments, the lawyers may properly discuss specific instructions. And during your deliberations, you must consider the instructions as a whole. Again, as jurors, you're officers of this court. You must not let your emotions overcome your rational thought process. You must reach a decision based on the facts proved to you, on the law given to you, not on sympathy, prejudice, nor personal preference. To ensure that all parties receive a fair trial, you must act impartially with that earnest desire to reach the proper verdict. In instruction 2, as jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence in these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors, nor should you change your mind just for the purpose of reaching a verdict. Instruction 3, the defendant, Mr. Arith, has entered a plea of not guilty. And that plea puts in issue every element of the crime charged. And the state is the plaintiff and has the burden of proving each element of the crime beyond reasonable doubt. The defendant, Mr. Arith, has no burden of proving that a reasonable doubt exists as to these elements. And he is presumed innocent. This presumption continues throughout the entire trial unless your deliberations you find that it has been overcome by the evidence beyond a reasonable doubt. Now, a reasonable doubt is one for which a reason exists and may arise from the evidence or the lack of evidence. It is such a doubt that would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or the lack of evidence. If, from such consideration, you have an abiding belief in the truth of the charge, you are then satisfied beyond reasonable doubt. Instruction 4, the evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. Instruction 5. A person commits the crime of assault in the 4th degree when he or she commits an assault. Instruction 6. An assault is an intentional touching or striking of another person that is harmful or offensive, regardless of whether any physical injury is done to the person. A touching or striking is offensive if the touching or striking would offend an ordinary person who's not unduly sensitive. Instruction 7, a person acts with intent or intentionally when acting with the objective or the purpose to accomplish the result that constitutes the crime. Instruction 8, physical injury means physical pain or injury, illness, or an impairment of physical condition. Instruction 9, to convict the defendant of the crime of assault in the fourth degree, as charged in count one. Each of the following elements of the crime must be proved beyond a reasonable doubt. Number one, that on or about August 23rd, 2025, the defendant assaulted Andrea Marie Underwood, and two, that this act occurred in British Washington. If you find from the evidence that each of these elements have been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction 10. An intimate partner means spouses or former spouses and or persons who have a child in common, regardless of whether they have married or have lived together at any time. And the final instruction, number 11. When you begin deliberating, you should first select a presiding juror. Presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. Deliberations occur only in the jury room when it says all 12. All 6 of you are present. You are all officers of the court and must evaluate the evidence with an open mind, free of bias or prejudice. If during your deliberations you become concerned that discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of your other jurors so that the issue may be fairly discussed among all members of the jury. During your deliberations, you may discuss any notes you've taken during the trial if you wish, and you've been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memory or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You'll need to rely on your notes and your memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during your deliberations. And if after carefully reviewing the evidence of these instructions, you feel the need to ask the court a legal or procedural question that you've been unable to answer, write the question out simply and clearly. For this purpose, use the form provided in the jury room. In your question, do not state how the jury has voted. The presiding juror should sign and date the question and give it to the bailiff, who is Ashley, and I will confer with the lawyers to determine what response, if any, can be given. You will be given the exhibits that are admitted into evidence for these instructions and verdict form for recording your verdict. Some exhibits again and visual aids may have been used in court but will not go with you to the jury room. The exhibits that have been admitted into evidence will be available to you in the jury room. You must fill in the blank provided in the verdict form the words not guilty or the word guilty according to the decision that you reach. You will also be given a special verdict form for the crime charged. If you find the defendant not guilty of the crime, do not use the special verdict form. If you find the defendant guilty of the crime, you will then use the special verdict form and fill in the blank with the answer yes or no according to the decision that you reach. In order to answer the special verdict form yes, you must unanimously be satisfied beyond a reasonable doubt that yes is the correct answer. If you unanimously agree that the answer to the question is no, you must fill in the blank with the answer no. If after full and careful consideration of the evidence, you are not in agreement as to the answer, then do not fill in the blank on the special verdict form for that question. Because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, fill in the verdict form to express your decision. Presiding juror must then sign the verdict form and notify the bailiff or Ashley, and she will bring you into court to declare your verdict. Okay, so we can set those aside and give your attention to critic.
On August 23rd, 2025, Matthew Arith hit Daniel Underwood and tackled him twice. He also grabbed Andy Underwood by the neck and pushed her. The state has charged the defendant with 1 count of assault in the 4th degree domestic violence on an intimate partner, the assault on Andy. And a person commits the crime of assault in the 4th degree when he commits an assault. Now we're going to look at the jury instruction number 9. I promise not to read these all. If you flip to jury instruction number 9, to convict the defendant of crime of the assault in the 4th degree, the state must prove 2 elements. 1, on or about August 23rd, 2025, the defendant assaulted Andy Underwood. and 2, that this act occurred in Thurston County. So jumping to the second prong of this, that this act occurred in Thurston County. Think about what you heard about this. Andy and both officers testified that this incident occurred at her home on Falcon Way in Thurston County. So that's not in question. Back to the first element, the defendant assaulted Andy Underwood. So let's turn to number 6 for a definition of what an assault is. Instruction number 6 says that an assault is an intentional touching or striking of another person that's harmful or offensive, regardless of whether any physical injury is done to the person. Think about the testimony that you heard, the body cam evidence you saw, and any photos you saw that prove an assault occurred. So first, you heard from Andy Underwood. She had filed for divorce the week before. His anger had been escalating. She kicked Matthew out of the house recently. He no longer lived at the home. He was just staying there to take care of the pets while she and her family was on vacation. She called him, talked to him, and texted him saying that they were on their way. When she got to the home, all the doors were locked. The child's safety latches way up at the top of the doors were on, even though he was home alone. You heard her say she banged on the door repeatedly. She finally had to climb through the window of her own home. Once inside, you heard her testify that the defendant screamed obscenities in her face. Then Andy had to remove her 3-year-old from the house due to the defendant's language, aggressive demeanor, and behavior. She had to have her dad standing by the house because she was afraid he would escalate. You heard her testify that the screaming and swearing did escalate. Her father had to come in the house due to the yelling because he was concerned for her safety. And then you heard both Andy and Daniel testify that once Daniel came inside, Matthew sucker punched Daniel right in the face. That's not in question today. Andy testified that Matthew not only punched her father in the face and tackled him to the ground not once, but twice. When Matthew tackled Daniel the second time, you heard Andy testify she pushed Matthew away to protect her father. To prevent Matthew from punching and attacking Daniel more as he had just done, Matthew then turned on her, grabbed her by the neck, and pushed her backwards towards the bookcase. She testified that her throat hurt afterward from where he had grabbed it and squeezed. And you heard her testify that he has a history of assaults. He's thrown things at her. That was why she kicked him out of the house. You heard from Deputy Graves. You saw his body camera where Andy and Daniel, the day of the assault, told Deputy Graves exactly what happened, moments after it happened, that Matthew grabbed Andy's neck, squeezed, and pushed her by the neck. Their stories were the same then as now. You heard Deputy Graves say he saw redness on Andy's neck, consistent with somebody having hands on her neck. And that didn't come across great in the pictures, but he had to use his flashlight in the picture. He was inside, the lighting was low. You also heard Sydney, who had been on vacation with her sister, say while they were on vacation, there were no red marks on her neck. After this assault, there were red marks on her neck, consistent with somebody having his hand on her neck and squeezing. All 3 witnesses, Andy, Daniel, and Sydney, gave you consistent stories. Daniel and Andy on body cam, same story then, same story now. All indicated that Matthew assaulted Andy. Hand on the neck, leaving red marks. Now think if there's any evidence that defense has provided to refute these claims of an assault. You heard Matthew's version of events, that nothing at all happened between him and Andy. They were yelling at each other, but nothing happened. He testified she never laid hands on him. He testified he never laid hands on her. But remember, you saw Matthew's interview with Deputy Wakefield on body cam, and he was essentially incoherent in that interview. Think about if you were able to understand him, if you sort of had to listen really hard to figure out exactly what his words were. If he was slurring his speech then. You had both sheriff's deputies who are trained in assessing DUIs and that kind of intoxication, and they both testified today saying that he appeared intoxicated that day. So perhaps his memory of the event is tainted by how much he had been drinking that day. And whether he was intoxicated or just full of rage or low blood sugar, as maybe they were claiming because he only ate a steak and didn't have carbs, whatever it was, it doesn't matter the reasoning. What matters is the assault happened. People witnessed it happening. People told the police that it happened, and people saw the effects after the assault. They saw the red marks. In considering Matthew's testimony, remember, you're only deciding if he assaulted Andrea Underwood today. That's the only thing that's up for question. His version of what happened on August 23rd has absolutely no evidence to support it. There's no body cam to support it. There's no physical evidence to support it. Both Daniel and Andrea had injuries consistent with their testimony, with the body cam, and with photos admitted to evidence, with what they told officers that night and with what they testified today. Matthew's claims that Daniel assaulted him is completely irrelevant in determining whether Matthew assaulted Andrea. And consider his inability to recall what happened. There were a lot of times where I was asking him questions and he just didn't really answer the question. Andy testified that Matthew has a history of assaulting her by throwing things multiple times over the years. You heard testimony about this earlier. Finally, I'd ask you to look at one last jury instruction, number 10. To prove assault in the 4th-degree domestic violence, the state must prove beyond a reasonable doubt that the defendant and the victim are intimate partners. And this just means that if the two parties were married or had a dating relationship, they were intimate partners. So this shouldn't be in question in this case. They're married at the time, they're actually still married, that's not up for debate. Finally, I'm going to read you part of jury instruction number 1. It's the second page of jury instruction number 1. You as the jury are tasked with the sole judges of the credibility to determine the credibility of each witness. You're the sole judges of the value or weight given to the testimony of each witness. As you weigh the evidence and testimony you've heard, think about the credibility of the witnesses. Think about how Andy and Daniel's version of the events that they told officers that night and what they are telling you today is the same. Please rely only on the testimony, photos, body cam, and evidence introduced at trial. Nothing the lawyers say is testimony, is evidence, I'm sorry. What we tell you or what the defense attorney tells you, that's not evidence. The defendant, Matthew Arith, lost control, maybe due to intoxication, maybe due to notice of impending divorce, but in rage, he lashed out both at Daniel Underwood and Andy Underwood when she tried to intervene to protect her father. He grabbed Andy by the neck and pushed her towards the bookcase, causing soreness to her throat and red marks. Now is the time to hold him accountable by finding him guilty of assault in 4th-degree domestic violence for the assault on Andy Underwood.
Mr. White?
So at this point, we heard 4 different versions of the events of that day, August 23rd, 2025. We're hearing your burden here today is to weigh that those narratives that you've heard, photographs and videos that you've seen, and weigh those against the standard of beyond a reasonable doubt in order to find Mr. Arith guilty of the assault in this case. In weighing that, we're basically asking you to watch it and determine what makes sense. The version of events that you heard in the video was different than the version of events that you heard from Daniel Underwood. which was different from the version of events which you heard from Andrea Underwood, which is different from the events that you heard from Matthew Areth. It stands to reason that the version of events that you heard from Matthew Areth and from the Underwoods would differ. What doesn't necessarily stand to reason is the testimony between the Underwoods would differ so much. Andrea testified that Matthew put one hand on her throat and another hand on her chest and pushed her back up against a bookshelf, or toward a bookshelf anyhow, over the pile of toys, around the pile of toys that you saw in the photographs there. Daniel Underwood testified that he put a hand on her neck, one single hand, didn't push her anywhere. The video suggested it was one hand. And then the photographs, despite the officer saying that there was low light, I mean, most cameras have a flash on them. So if he was trying to illuminate the injuries with a flashlight, that seems a little strange. Additionally, the photograph does show redness on Andrea's cheeks, redness on other parts of Andrea's body. There is no real visible redness on her neck that would suggest that that there was any contact with her neck or any sort of harmful or offensive contact with her neck. Andrea wants you to believe that, you know, despite being locked out of her house, banging on the door, having to climb through a window, having his truck parked in her garage, that she walked in calm, cool, and collected, and everything was normal. I mean, the reality of it is that when she walked into the house, the only person who sort of walked out into that strange situation was Matthew himself, coming out from the shower, seeing her there, asking for a moment to put some clothes on because the family was coming in. And by the time he had an opportunity to come open the door, she was already in the house. There were some conversations about injuries to the daughter. All this stuff is obviously framed in the situation. I mean, the reality of it is they were separated. This was no longer a healthy relationship. But as Daniel Underwood testified, it was kind of coming from all sides. It wasn't a one-sided situation here. There's no argument about whether or not Matthew and Daniel got into a fight. I mean, that's kind of obvious, and we're not here to decide whether that took place today. What we're here to decide, what you're being tasked with deciding, is weighing the information about the alleged assault on Andy, the alleged harmful or offensive touching there. Mr. Areth denies having put hands on her, or at least denies remembering having put hands on her. Obviously, part of his mental state is going to be part of that calculus that you're going to have to do. The video there, I feel, is very telling, because Andrea testified that she didn't really smell alcohol on him at all. Daniel didn't mention any smell of alcohol at all. The officers mentioned a smell of alcohol, but not necessarily to any severity that caused them concern to look into it further. They didn't do any investigation into any sort of alternative causes for Matthew's disorientation. And I mean, you are able to use your sort of common sense and common experience to determine, you know, whether the behavior that Matthew was showing in that video, or the disorientation that he was showing in that video, would have been caused by this questionable presence of alcohol or by something else. That being said, again, when it goes back to the assault, the issue that we have to focus on is that not only is it a harmful or offensive touching, but it's also an intentional harmful or offensive touching. So, sort of, I don't want to say incidental contact, because that sounds a little strange, but placed into this environment, this chaotic environment where there's so much physical contact happening between people, in such a small space, where there's obviously a fight taking place between Daniel and Matthew. The question is, was there any intent to make physical contact with Andrea by Matthew? It's possible that he made contact and didn't remember. It's possible that he made contact and didn't, it just maybe didn't register with him because it wasn't what it was being described as. It's possible that there was no contact at all, that this was something that, came up as a way of, distracting attention from law enforcement to some of the other things that were happening. But either way, I guess the question there is about credibility between the witnesses as to whether you believe that Matthew intentionally made physical contact with Andrea, whether that happened at all, if it did, whether it was intentional, whether it was just being caught up in sort of the chaos of the moment here. And then weighing that against the photographs to determine, what's the likelihood of that having happened, weighing it against the other photographs of the space, weighing it against the videos, to determine again where the credibility lies here. What beyond a reasonable doubt took place. And if you can't determine beyond a reasonable doubt what took place, or if you can't determine beyond a reasonable doubt that an assault took place, then you have to find Mr. Arith not guilty. And we think that if you take the evidence that's been presented, weigh it fully with that in mind, weigh the officer's testimony over what they did or didn't do in interviewing the situation. Why did they interview Daniel and Andrea in the same space at the same time when that's not a best practice? And the officer said more often than not he wouldn't have done that. Why would they do it that way? He said that they were correcting each other's stories, correcting each other's narratives, which is exactly the reason you don't do it that way. But again, they in weighing that credibility, we'd ask you to consider just that you've got 2-3 family members here that are providing the same narrative of the story, and Mr. Arith is only here providing his own narrative because that's the situation he finds himself in. Based on that, I think that once you weigh all that evidence and review everything, which we ask you to do again fully and carefully, you'll come to the conclusion that Matthew Arith is not guilty of assault in the 4th degree against Andrea. Thank you.
And pretty can you get about 10 minutes?
Okay. Just want to address a few of the things that the defense counsel brought up. He said there were 4 versions of events. I would argue there's really just one version of events. You saw the testimony from Andy and Daniel today. You saw the version on the body cams. Minor differences, but remember, as I talked about in voir dire, when every time people see an event, if 2 people see the same event, they remember different little bits. They might forget one little part, remember another little part. Everybody remembers things slightly differently. And this is now an event that happened in August. So there's going to be minor little differences, but overall, their testimony at the time, their testimony today was almost identical. In terms of the officers in the video using the flashlight, he was trying to see the injury better. And I think that's a good practice if you can't see the injury. The lighting in the house wasn't perfect. Could he have taken her outside? Sure, but he didn't. Instead, he used the flashlight. And then he testified today. Yes, there was redness on her neck. Her sister testified. Yes, there was redness on her neck. But even in your jury instructions, it said there doesn't need to be injury from an assault. An assault is just the harmful, offensive act of touching somebody. There doesn't need to be an injury, but in this case, there was. Matthew Arith denies having put hands on her. And the defense attorney was talking about intentional contact, whether this contact was intentional. But if you recall his testimony, he said, I never laid hands on her. I love my wife. I would never lay hands on her. You can't then go around and say, oops, well, I might have, but it wasn't intentional if I did. It doesn't work that way. Either you didn't touch her at all, or you did and it was a mistake, but you can't testify and have your entire testimony be, I never laid hands on her and I never would have. The defense attorney then said that there maybe in moments of chaos this happened, that he laid hands on her. Let's think about this. In moments of chaos, he put his hand on her neck and squeezed. That doesn't sound like a moment of chaos. That sounds like a very intentional act. That's not like, oops, I shoved you with my elbow, I'm sorry. We were brawling, I might have tripped you. Putting your hand on somebody's neck is not an oops. Pushing them by their hand on their neck is not an oops, a moment of chaos, oops. In terms of the comment about officers not doing a breathalyzer, they had no reason to. He wasn't getting in a car to drive. He was being arrested for assault. So that's not something officers routinely do. And they both said we had no reason to investigate the alcohol issue further. They were both knew that he wasn't going to get in a car. He hadn't been driving. He was in the house. He was intoxicated. They smelled it. They observed it. They're both very trained observers in this. They're not EMTs. They're not trained to go through the medical lists of what could be wrong with this person. And in fact, had they thought there was a medical emergency, I'm sure both of them are more than trained to call for an ambulance, which did not happen. I think the defense is grasping at straws here. They mentioned things like the both witnesses were interviewed together. Yes, they were. But you had the officer saying, we do that, particularly when we have no doubt that, they have no reason to lie. They weren't lying. He had no thought that they could have been lying. So he was fine with them being interviewed together. He said the only time that they really feel a need to separate two people is when maybe they're giving false stories or feeding off each other, giving, oh, well, this is a lie. If they have reason to do that, then they will separate them. But it's perfectly fine for them to have both been interviewed together. The officer said that. They're trying to throw a possible head injury in there at you. They're trying to throw low blood sugar in you. They're now trying to throw in accidental contact at you. That's not what this was. This was a very clear assault. He grabbed her by the throat. He was angry. He was mad about being kicked out of the house. He was most likely drunk. Grabbed her by the throat and squeezed her throat. We feel the only option is to come back with a verdict of guilty of assault in the 4th degree domestic violence. Thank you.
And now, we'll be putting into deliberation, and Divine, who's putting 6 of you in deliberation. You pick the 7th juror there just in case, and I'll tell you what your duties are, and then we'll get you into deliberation. But one thing I want to suggest to the other 6 is that you don't deliberations, as you see in your instructions, are only when you're all in the jury room together, all 6 of you. But I would suggest take a little break, get a snack, have some water, get refreshed a little bit, and then start. You'll pick that 4-person, and then you'll get going. However long you take is entirely up to you. It's not up to me. And so we'll see where you go with it. But Senator, you're still part of this jury. You're not excused yet. We picked you just in case something were to happen to one of these 6, and then you would be brought back, and it would begin from moment 1 again, begin deliberations again. If that, in all the years I've been doing this, we've had people get into car crashes and not be able to come back, get horribly ill and not be able to come back, things like that. And it doesn't happen often, but we're always careful. And so that's why we picked you. So Ashley's going to get some contact information from you, and hoping that you can be about 20 minutes from the courthouse. she's going to be in touch with you more directly about whether you'll be coming back or not coming back as soon as we know. Certainly by the end of the day, we'll let you know what's going on by 5 o'clock. And so you're still part of this jury. So your job is that recess instruction still is you don't talk to anybody about the issues, the facts, the testimony, the evidence, the people. You don't look anything up. You don't go research anything in any way, shape, or form. You don't go give the place where this is alleged to have occurred any more interest than Sunday when, if you travel through there naturally to go wherever you're going, you don't stop and look any more than you would have on Sunday before you were picked for this jury. Remember, you tell people I can't talk about it, tell you all about it later because you will be relieved of this, and be careful with your social media contacts so that you're not inadvertently violating this oath that you took by people sending you information that you can't avoid. So Ashley, I guess I put you in their hands, and then you can, again, take a break. I would suggest the other 6, and then Ashley will get information from you, juror 7, and start your deliberations, and let's see where we are. Thanks.
Thank you for joining us. I'm Jennifer Homendy, and I'm the chairwoman of the National Transportation Safety Board. With me today is John DeLue. John is our